we're now recording, and I am so excited because Darren Welsh is our, as you know, he's our company attorney in all three states. He's absolutely amazing, and he's going to review some of the 2021 laws with us and what it means to you and your business. So get ready to take a lot of notes. He's going to start, and then when he's finished, I'll have about 20 minutes of documents that's going to help you get through all of the new changes. So we're going to work hand in hand here. I hope you have your pens and papers ready to go. And so without taking up any more of his time, Darren, welcome, and thank you so much for being here.
Hello, everybody. How's it going? Everybody can hear me okay? Thumbs up. So how's your weather? Is it snowing there? You guys got some clouds? Yeah? Anybody? Not a single person is unmuted. Hey, so you really don't have to take too many notes. What I did was I took the memo from Carr and I just enhanced it a little bit and put some yellow highlights. And Gina will email this to you when we get out of this meeting, okay? Because if you look at what happened for the, there we go. Now we get to see what Netflix movie she was watching last night. All right, there we go. So this is approximately 60 plus pages. And what I did was I took all of the new laws that came out, and I numbered them. The PDF that came from Carr didn't have a page number, so I numbered each of the pages, and then in my notes here, if you want to go and dive deeper into it and have specific questions, because each one of these is about four highlighted ones of these about 20 new laws. If you want to dive deeper into it, you just follow the PDF, the other one that Gina's going to send you, and you can see down on the page number and get to that, and then you can read, in any specifics. So the first one is the Proposition 19, which controls and is trying to affect taxes. As we all know, it's 1% of the sales price in California, which can be quite the impediment. If you bought your home and everybody's got parents or whatnot, and I still consider myself, I don't know what, we all have some age that we consider ourselves, right? So I think I'm like 28 or 25 still, and even though I'm 55. And so when you do hold on to property in California for a long time, you do end up with that tax advantage because you may have paid literally 30% or even half of what a neighbor has paid, and therefore your taxes are lower. So Proposition 19 did the best to try to take what exists in inventory. And if you're 55 years or older, and then you've got some exceptions too. So you can be severely disabled. You could have had a home damaged by wildfire, and you do not want to rebuild, and you want to sell your lot and move on. And so the replacement residence has the tax advantage because you are able to take the original value of the home that you are selling and apply that as a value to the home that you're purchasing. So if you bought a house for $350,000 in 1988, and you're going to go buy an $800,000 house, you are going to be able to take advantage of the earlier gross sales price as to your tax annual bill. And so that's quite a savings, and it's an incentive for certain groups to be able to do that. And it's anywhere in California. So you could sell your home up in Humboldt and then in the north and come all the way down to Palm Springs, et cetera, which is, so I don't think it's gonna have too big of an impact, but it certainly is going to help for especially our older crowd. There's also, if you get deeper into it, there's more that where you can sell the home to your child, and it has to be used as a residence. It can't be a rental. When you kick your parents out of the house to start making money, when you move them into some, old folks home kind of thing. So there's more detail to that if you want to go deeper into it. But basically, you're going to have anybody that's over 55 that's staying in California and relocating, that's going to be quite an advantage for them. And you have 2 years to do it after the sale, which is a sizable amount of time. If anybody ever been involved in a 1031, you have way quicker deadlines when you're trying to do a tax exchange on a commercial on an investment property. So you could sell today and you don't have to close escrow on your next one until 2023, which seems really far away, and in reality it's going to be here upon us before we know it, right? So Gina, if you'll scroll down, the next one is the home hardening disclosure. This is for fire affected properties, and this is for this isn't a new law, and it's only for homes built before 2010 because of the standard of building changed after that, and so you don't have it. It's very similar to lead-based paint. So the way you go back in time on lead-based paint, and this law is not new. It's just that it's been enhanced a little bit. And again, you want to go deeper onto page 14 on the other PDF that Gina's going to send you. You can read about it. And this is a disclosure for homes that are in a designated fire hazard area, that's going to be, that's not everywhere, but it's going to be certain high fire areas that you're talking about up in the lakelands, et cetera. And this will it's going to apply to any property where the TDS is required. And it basically talks about what precautions the seller has taken in changing their house and whatnot. It's really an insurance issue. We're going to see probably, you're going to see pretty dramatic homeowners insurance in general is going to go up as we march on here. Here's a weird statistic. So the United States pays attention if a disaster causes more than $1 billion of damage. Okay. And so we have on average something like 7 to 10 disasters in the United States on an annual basis above $1 billion. There were 22 in the year of 2020. I just was looking at that. So there's 22 disasters above $1 billion. You're talking drought, hurricane, and fire. Those are the three biggies, right? So it sounds like we're in Bible class. So the home hardening disclosure, like I said, exists already, but for those of you that are selling in those areas, this is going to be something that's going to be required by lenders much more. And then we move on down to, this is an interesting one. On the handout from the cards, both page 4 and 38, I think it may be a repeat, but I put that in just because I don't know if there was some slight change in one of the Senate bills or Assembly bills. But it's this is the right to rent out your unit in a common interest development. So no matter what the rules are of a gated community, of any area that has a overlay of the homeowners association, they have come in with an overlay that said at least 25% of that neighborhood must be available for rentals. So if you live in a neighborhood right now and your CC&Rs are, for example, there's no renters allowed at all. Renters are not a protected class. So you're allowed to say, we're all going to be, no one's allowed to rent the property out. You can only have family live here, et cetera. So the legislature overrode that and made it automatic that 25% has to be available for rent. And that's a little bit of if you're dealing with investors, it's hard because it's not like there's some ticker symbol, on the wall when you walk into that neighborhood that says, we're at 26% capacity right now, and as soon as Bob's renter leaves, then you're going to be allowed to have a rental in this neighborhood. That the only way you can figure this out is you have to get back to the HOA and talk to them about what their strategy is. And for those groups that do not allow rentals at all, this is brand new for them. They're going to have to come up with a system. And for those who were at 10% or 12, they're going to have to increase it. And it's just always it's always a question of how they deal with an occupancy. So if you do you already have a rental and then your renter is about to leave? If he's vacant for 6 months, are you now out of it can be very devastating to an investor to own a home and all of a sudden not be able to rent it out, or to buy a home thinking you're going to be renting it and then learn later that the HOA is at capacity. So that's an important note that we don't want to get in between a rock and a hard place on. I've had these scenarios where people have purchased expecting to live there, say 2 to 3 to 5 years when they retire. And in the meantime, they're going to be renting out the condominium, the home, whatever. And then they find out from the HOA that they're not allowed to do that and they're going to get fined on a daily basis. And so obviously then the first thing they do is blame us, right? And so if this is all about communication, you know, when you're talking to your buyers of what it is they expect to be doing. And if they say, I'm looking for a rental property, and if you're buying a home that's owner occupied and it's not a rental, you want to, this is something that a buyer needs to worry about if they're going into strict CC&Rs and or an HOA. So, and the other thing about this new rule on the right to rent your unit is, so any right that you have now through your CC&Rs or your HOA cannot be diminished. So in the past, as long as you had enough votes, the HOA could go in and say, hey, we had a vote, we followed the rules, we had a quorum, et cetera, and we have now created a moratorium on renters. Or we've decided that only 25% of the neighborhood can be rented out. Well, that's no longer possible. So if you, whatever your rights are as of January 1, 2021, the HOA is not allowed to go in and diminish them, which is, to me, that's a more, forcing them to rent for 25%, because I don't know that all HOAs had any type of limit on renters, but it's not uncommon in my experience that an HOA gets to the point where they get a certain board and they get a certain amount of votes and they decide to start doing some restrictions that will limit renters, and that has been eliminated. So no matter what, the existing rights that the owners currently enjoy to rent out their units cannot be changed. That's crazy. That to me, that's a more controlling action than it is even to make sure that it's at least 25. All right. So moving on, this one is just on tenant prospective owner and nonprofit right of first refusal. It doesn't really have anything to do. It's not going to affect this, page 28, SB 1079. I don't think this is really going to affect our involvement in our lifeblood and in our heartbeat, which is resales and some new home, but mostly resales. This is an interesting part of foreclosure moving forward, and that is if someone is foreclosed upon, not the homeowner, right? So if you're foreclosed upon, this doesn't apply to you. But if you're a tenant, you have 45 days to match the foreclosure sales price. So the example is the home has $500,000 of debt. It's in foreclosure, goes through the foreclosure process. It is sold through the necessary steps, either at the courthouse steps, or sometimes they just have a designated place at the bank where it's going to be, goes to trustee sale. There's bidders. Oftentimes the lender is the highest bidder because they can do what's called a credit bid. And so now the debt for $500,000, the house is sold for, let's say, for example, $300,000, which is not really going to happen in this market, but just for example. If that is a non-owner occupied home, then that sheriff's deed is not valid until the tenant has waived their right and 45 days has passed from the 45 days has passed from the trustee sale. How administratively bonkers crazy is that? So this is one more bizarre, wrinkle when you're buying it for investors that are down buying homes in the foreclosure process. So the tenant has a 45-day to match, and then an investor actually, so it states here, tenants or prospective owner occupants. So they've got a 45-day window, purchase the residential property through foreclosure if they can match in the case of tenants or exceed in the case of other purchasers. So an investor has to come in with just a little bit more. And I can't remember right now if it's like the way probate works where you have to come in at $5,000 increment, but you just have to come in with a little bit more. So that's an interesting wrinkle, in my opinion. I guess what they're trying to do there is sometimes foreclosures occur, no one's paying attention, and this home sells for 20%, 10% below market just because no one has enough time to follow what's going on with all the foreclosures. And so if you're a tenant and you realize that your landlord's property was foreclosed upon and it's something you might be able to afford, you have 45 days to go get a lender and try to buy that home from the investor or the bank who took it back, which is now in the recession. If we go back to a recession, and God forbid that ever happens again, but that would be very interesting because we saw massive amounts, especially in the high desert. We saw a large of decrease in value through the foreclosure process. But again, I think that's almost just exciting because we're in real estate. I don't think it's going to affect us on our resales, right? And then the statewide rent moratorium. I don't know if you guys. The next one was AB 3088. I don't know if you guys sat through or listened to. I did a small update on rentals in California, and so where we're at now is basically there's three tranches or two tranches. There's two areas. There's last summer and there's now, right? And so last summer there was a moratorium on evictions for residential. It was modified in the fall to say, look, you can't go retroactively and kick someone out for not making that payment during the first moratorium, but they still owe the money and you can pursue them at a later date. Then in the fall, they changed it to if residential and if you're COVID related, you're COVID affected, then you have to pay a minimum of 25% of your rent. And again, you cannot be kicked out for the remaining 75%, but the 75% is owed. And that was to expire in January of 2021. That has all been extended. Well, I'm sorry, it was going to end in the fall and then we moved it to the end of the month we're in now. But you should know, as I put in the note here, what's happened in peripheral states and probably what's going to happen in California in the next couple of weeks. Where are we? January 20, we're probably in the next, we might see a change in like a week from the governor. And that is, it looks like for the most part, everything is moving to March 31 for the rent moratorium, right? That's what the CDC has done. The CDC has its own overlay. It doesn't talk about money. It only talks about health. And it states that if you make under 99,000, you're affected by COVID, you have nowhere to go, you're going to be homeless, or you're going to converge two families into one. Then the federal government overrides the state government and says you cannot evict that person. And that just came out with COVID CARES Act number 2. And so that's affecting Puerto Rico all the way to Hawaii. That's everybody, right? And so you're probably going to see California move its 25% rule to the end of March. They haven't done it yet though. But what's interesting is, what's good is the moratorium does not prohibit us from talking to the tenant. So if we have a renter and we are trying to sell the home to an owner-occupied person, and that person is on a 30-day notice, then you can still evict. And I highlighted it here for you. You can still evict a tenant for no cause if the owner is in contract to sell or buy to a buyer who's going to take occupancy. So if you're not selling it to an investor, you still have the control to actually forcibly evict the tenant on a no cause. And a no cause would be that the lease is expired and now you're on a month to month. That's when the terms of the lease carry forward, except for the term, which is 1 year now or 2 years now, reduces down month to month. Okay, and in my opinion, that gives us the opportunity to talk to the tenant. And that's what's going to be most important in these scenarios. It's just back to what we do best and what we're most important for, and that is we communicate with human beings, right? We have to go in there, see what their desires are. We're trying to get this house sold. It's going to be owner occupied. The tenant says I'm under the CDC rule. I may very well not be evicted. That is true if they comply with the CDC 4 guidelines, but you can discuss it with them and see if there's some sort of middle ground that can be reached to see if they want to take cash for keys or something and move on. It's all up to your seller, how motivated they are to get the property sold, right? So those are, in my opinion, those are the big ones. And again, if you want to get any, you guys don't have enough to read, you don't have enough to do, or you've been at home too long with your spouse or whatever, and you just got to find something else to distract yourself. Like, you can take the 60 pages that I attached to this and read in depth, right? We don't have any really terrible holidays coming up that we have to spend too much time with our family. So we're kind of safe for a while. Like in Thanksgiving, this is the kind of thing you want to bring, right, to a Thanksgiving holiday. So you can pretend like you're busy so you don't have to talk to uncle whoever. You know what I'm saying? Actually, that's one great thing about COVID is we don't have to deal with any of our family anymore, right? Think about how many holidays you've got to skip, etc. You know what I'm saying? Okay, moving on. And then I just did some other notables at the very bottom. So on page 9, there's certain contracts that if you're over 65, you were allowed to cancel. Not real estate, not purchase and sale, but certain things like if they came to your home and sold you a vacuum, if you signed a lease agreement, you had 3 days to cancel if you were 65 years or older. So again, if you go to page 9, you can see the exact list of the contracts. It's not purchase and sale of real estate, but it is a lease. That got extended to 5 days. All right, so 3 to 5 days that person has to that much more time frame to change their mind. On page 11, we've always had a rule that a translation, if somebody is negotiating only in one language the entire time, that we have this amorphous, kind of untapped law that says you must do a translation of the document before the person executes it. And it used to be the person executing it. And now it's been expanded in a weird way that kind of is no change at all, but it is a change, and that is all signers, all parties. So, for example, if somebody was signing a lease and they were the only one signing it, and the landlord only expected, the husband to sign and not the spouse or something like that, and that was okay, which it does work. Like, for example, you can sign a listing, only one person has to sign, even though all the owners are husband and wife are both held to the listing agreement. Now everybody's got to get a copy of the translation prior to the execution. So it's like, it's a change, but it's not really a change. You probably did that already, but now they've expanded it to every single person that is a party. Another fun one is not really affecting us, but it does, just because this is something that title has to deal with us, and that is the RT, the revocable transfer on death deed. So that rule, the RTDD, which allows you to basically not change, you don't have to go in and deal with the title of your property in California, but it's an interesting, cheap way to handle probate, because you are allowed to go in and file the RTDD and direct who gets the house. So, and then you avoid probate. So it's basically like a joint tenancy with right of survivorship. So as soon as upon death, without any action, the home is automatically transferred. Title sees that, they realize that's accurate, and so what they do is they just make sure the death certificate has been recorded, and then you avoid probate, right? So you're allowed to do that. One of the interesting things that we have is the RTDD, and it was set to expire. It was written years ago, and it's been used and whatever, and then they had a committee. You could read about it in the pamphlet that you're going to get. We had a committee, and it said that it's confusing, and they wanted to revamp it and change it. And so the law actually sunset. So meaning it was written and it was only to be on the books for X number of time. Well, they extended it for 1 more year because they do want to keep the RTDD in place, but they didn't have time because of COVID to address it. So they saved the form, and that, which is, it's quite an interesting thing what you can do there. I mean, you can, and you know, if you really want your children to behave, you can change the RTDD every day, right? So you can go in and record that somebody gets this property, and then if they don't, you know, your birthday comes, you don't really get enough gifts from 1 or 2 kids, you alert them via email that you have gone down to Riverside County and you've recorded a new RTDD without anybody knowing what it says. And it's just like, hey, you know, Valentine's is coming up. Perhaps you want to think about getting me a little bit bigger gift this year, right? Kind of thing. And so, but if you think about the ease of that, if you have somebody like, I want everything to go to person, that person disappears, marries the devil, you know, you don't want them to inherit your home anymore. If you think about the ease of this, you can go and record another one, and you can literally transfer that house to someone else, and it becomes a joint tenancy. So it's quite a form. It's probably the future. I don't know if California made that up, but I've never seen that. That's a unique thing that we deal with here that I really like. So that's what I have for it's 9:57. So we've been talking for 27 minutes. Oh, is there more? I didn't even go to my 3rd page. Couple more. No, sorry, there are 2 more. So another thing that's interesting that's not really going to affect us directly, but we're going to see changes for fire zones from here on out, right? And if you look at page 24 on that assembly bill, this is called a defensible space surrounding. And for specified high fire hazard areas, you're going to see a lot more enhancement, a lot more scrutiny on how homeowners are dealing with clearing the space around their house. And if you're selling in specified high fire areas, you're going to find that that's going to become an issue compared to, you know, pick another issue in another location or whatever. But this is something that you're going to be dealing with, both on the you know, specific requests for repairs, and it may come in from lenders as they educate themselves on the concept of you know, we don't want to lend on a home that's going to burn to the ground, et cetera, et cetera. So this is something that's just like, again, it's new, and we're gonna get used to it if you're in those areas. So if you're living in downtown Los Angeles, you know, it's not going to matter to you. If you're on the outskirts of Anaheim Hills, you may very well, this is going to be something that the government is going to come in, neighbors, et cetera, are going to be coming in and talking about this. On page 29 and 30, again, kind of a strange thing, but I did want to share it with you, not really going to affect us, but there is a foreclosure bill of rights, and it's specifically talking to small landlords. So these are going to be persons who are not owner occupied. They have their own rules and protections. This is someone who is renting the property out, and something has happened as a result of COVID, and you are unable to pay your bills. Now, it's not any type of a grant, it's not monetary, but it's more administrative blocking for the consumer protection. If the consumer is the landlord who owns not a number of homes, but just a few, in order to force the lender, in a sense, to sit with the landlord and try to work out with them a plan. I don't know. I mean, a lot of times these things are simply, they sound better than they really work. But in the end, you know, sometimes what happens is the landlord is allowed to basically have like a forced mediation with the lender, which ultimately ends up in foreclosure anyway. But it's a start. It's a start. I think what's really going to have to happen is if we have a crisis across the United States of small landlords that are losing their assets, their investments that they're trying to build up for 10, 20, 30 years when they retire. And then all of a sudden they have a tenant who hasn't paid rent in excess of 12 months. I mean, somebody could easily not have paid rent since April of last year. And now we're probably going to see somebody, so that's a year, right? Because the CDC moratorium is now spread all the way to March 31. Therefore, arguably, you're going to have somebody who hasn't received income, and it could be on every single property they own. Well, that's a disaster, right? Unless they bought cash or something. But if they have 3 rental properties and their own mortgage, and now they have 4 mortgages that they've been paying this whole time, they may have cracked and fallen through. And so that's something that we have to kind of wait and see what the data shows across the United States and in California. If these small landlords are being destroyed, then what type of relief? Because there's one thing about saying let's slow the foreclosure down compared to here's a grant like a PPP loan that you don't have to pay back as long as you prove X, Y, Z. All right. On page 34, the homestead increase has moved up. It used to be like 75. It was a scale. It's moved all the way to 300, potentially to 600, depending on the area. So there's a formula, and you get to take it into consideration the value of resale, even if you only have so much equity. You know, you take the median price in your county. So that's quite an increase in the protection of a homeowner. And homesteads are amazing. Again, doesn't really affect us. This is just something that you want to tell your occupied buyers to go and record, because a homestead is the most Teflon protection from a lawsuit. And that is, it works like this. If you lose a case and you owe somebody $100,000 and they go to try to take your house, and you don't have too much equity, you're within the rules of homestead, they cannot take your house. But greater than that, the $100,000 does not sit outside of your front door waiting for you to sell. It literally folds away. So you can sell that house in the next 10 days and keep all the money. So, and unlike like if you have an LLC or something, you'll see people talk about what's called a charge, and then debtors have all these judgments around them, and those judgment holders cannot attack an LLC. They have to wait, but it doesn't expire, it doesn't go away. Whereas a homestead, you are protected, and if you meet the criteria at the time, that debt never links to that real property. So it's quite the this is how powerful homesteads are. I mean, you got guys like O.J. Simpson who have a judgment of zillions of dollars against them. And if you live in states like Texas and Florida, there is no limit to a homestead. So you can have a $14 million house on the beach in Florida, owe someone $1 million, they can't touch your house. California, we don't have that, but this is how powerful homestead is, and it's for the small amount of money of getting them recorded once you buy your home. They're very important. And then finally, page 34, again, it's not really anything on our resale world, but it does limit foreclosures. It has eliminated the ability for a homeowner to be foreclosed upon if the debt was consumer debt. So if you've gone out and borrowed money for a jet ski, et cetera, and then they put that on your home, the lenders now have a grave inability to foreclose on that property. You're secured, unlike the homestead that folds away. You're secured, and if they were to sell in the future, that's fine. But you just can't remove that homeowner like you used to be able to on consumer debt for foreclosure. So it's just one more consumer protection. Doesn't have anything to do with us unless you guys are out there lending hard money like a loan shark. Then you're probably going to read page 34. So I think that's officially all I have, Gina.
Actually, Darren, did you want to talk a little bit about the DOJ and commission?
The new rule with the commissions?
Of having to disclose to the buyer?
Yeah. So, new rule, in exchange for a settlement that NAR performed with the Department of Justice, is our industry is taking a turn on a dime, and we are going to move into an era which is completely difficult now, and in 6 months or a year we'll be really good at it. But from here on out, all co-op commissions have to be disclosed to the public. So the buyer, just like when you go on the internet and you see a house for sale and it's $700,000 and they might list how many bedrooms or whatever, it's going to say what the co-op commission is by settlement with the DOJ. So the federal government has cut a deal with NAR to do this. I don't want to go into big detail, but if anybody wants to talk about it later, we are, as an industry, we engage with the DOJ often because they are consistently concerned about antitrust. Anybody that's involved in the board anybody that's involved in any type of committee through the boards or organizations that are really linked to being a realtor, you'll see when you sit down and you get your little piece of paper or your name tag or whatever, it'll often say, it'll list the rules of antitrust. It'll talk about the fact that we do not discuss commissions, et cetera, et cetera. And these are all those little warnings that might seem out of place if you're a volunteer down at the board. That's the result of various DOJ concerns over the years and settlements and compromises that we've come up with. This is a new one. So every single buyer is going to be able to know the commission. Buyer, the hard part to understand is the folk that, the big no-no that we have in real estate up until a month ago is that you were not meant to negotiate your commission inside the purchase agreement. Why? Because your first loyalty goes to your client and you want the client to get the house. So the fact that the listing agent is offering a commission that you don't want, that you'd like it to be greater, that is, you're walking on thin ice there, because are you more concerned about getting paid than your buyer getting the home? So we never talk about commission when we negotiate sales. You will see it here and there, right? For example, a seller will write back and say, I'll sell you the home, but your buyer's agent doesn't get to get any money. And that's a quandary that we come up against, because the co-op is not to be addressed at any time pursuant to our rules, right? Now the co-op is going to be known by the buyer, and the most confusing part is they have not clarified this because they don't know what they're doing. It sounds easy, but if the buyer or somebody starts to change the commission, or the seller and the buyer get together and they start to change the commission, where does that leave us? And that's the uncharted territory. 99% of the time, this is not going to matter. You're going to write an offer, co-op is X, the deal is going to go through just fine, it's going to happen. It will come up though, where based upon the new standard, that somehow the commission is going to be affected, and whether or not we are going to have no say at all in the in that is yet, it's an unknown. Here's the answer. When you deal with a buyer, you sign a buyer's brokerage agreement. It's that simple. That's what you do. And that's going to be the change in the industry. And I thought this was going to happen 10 years ago, and it never did. But I really thought before we ever got into a car with anybody, we sat down with our client and just said, listen, here's my agency disclosure. Here's my commission agreement. What's that? Oh, so I'm going to get paid this much on any house you buy. Most of the time, the seller's also offering a commission, and that will automatically go against, what you owe me. I like the buyer's brokerage agreement. I've had a hell of a time in court enforcing them. I will share with you, because, we get into real court, and literally the judges will say to me, but isn't that something the seller pays? It's crazy. So we've got a lot of energy pushing against us, but the answer to the new rule is the buyer's brokerage agreement. It's that simple. And I think Gina's going to go over that with you guys today. And then that clarifies that you're a professional and you're going to get paid. And this takes a lot of time. And if the buyer says there's no way I'm signing that, we cross that bridge when we get there, but I do think that's the future that way, because one of the things about the settlement, if you read up on it, is the argument for the DOJ is always the consumer. They're worried about the consumer not getting their fair share. If there's garbage fees, they worry about that. So when you have a co-op of 4%, and then you have a co-op of less than that, the argument is, well, the buyer's agent isn't showing the property that has the lower co-op. And, without getting into too much detail, that harms the consumer. The consumer should be allowed to buy the home with the lower co-op, because they say technically that it allows them to get a lower price. And then they do these wonderful graphs that show, look, This is how much money allegedly the consumer is overspending on real estate as a result of certain commissions and certain searches. So right now, 6 months ago, you could search for a property based on the co-op. That is part of the settlement. You can no longer do that. Now, what the DOJ, in my opinion, misses is that, hey, if Ford is selling F-150s and they're giving you a $10,000 credit in upgrades to your truck, there's a pretty good chance they've worked that into the price and they're not really giving away $10,000, right? And it's the same for a new home project and the condominium project that says, look, the co-op is 5%, it's 10%. Well, that's much higher than what we've seen in past. Well, the developer, we know, has incorporated that pricing, that offering into their profit scheme, and and so it's, to me, it's like, it's kind of simple thinking that it's just so obvious that if the co-op is higher, then the consumer's paying more, or well, I don't really buy it, because that home price could be higher in the beginning. A lot of times the co-op offering is higher. It's contingent on something else. Has to be at list price, which is, you move $1 off the list price, and now that seller is no longer obligated to a co-op that they agreed to because there's a contingency. So whatever. You just got to remember, we are a federally backed industry. So if we don't have loans, we don't have an industry. And so the DOJ will always be watching us and talking to us and helping us care for the consumer. And this is the latest rule change. This is a 10-year settlement. And so it can be readdressed in 2030. So some of you guys won't even be in the market anymore in 2030. You'll be safe. I unfortunately signed a contract with Mark Stark. I have to work till I'm dead. So cross fingers, if I manage to die off before 2030, I won't have to deal with the new rule. But I'm pretty confident that in 2031, I'm going to be on TV here with you guys explaining the new crazy thing. So I think this is one of the most uncharted territory things we have to deal with right now. And I think the first easy, simple answer is a buyer's brokerage agreement. And from there, as a collective group, we're going to learn. We're going to see what happens to other people. We're going to see how other negotiations go down. Things will go through the court system, and we'll learn more. We'll learn more. The silver lining, in my opinion, the buyer's brokerage agreement is going to become more respected in the state. Because I've sued on buyer's brokerage agreements on you guys' behalf, and they're tough. I mean, you're in shark water, when you get into the court system, and they want the buyer to pay something that they basically announced that they didn't understand what they were signing. That's their best defense, because it's like petting a dog the wrong way. Consumers, courts, people at a barbecue that you talk to, they don't really understand the buyer's brokerage agreement, which, they understand it when you sign up with your attorney. But we're not the most respected industry in the country. So there you go. Any questions? Sorry if I went over.
No, thank you. That's very important. And just so the agents are understanding, in the past, we go on the MLS, we search for properties, and we put together what we believe or perceive to be the best properties for our clients. And sometimes we do look at that commission and we see 3% or we see 2%. And in the past, agents have put the 2% listing aside, and let's show this 3% first and see if the client likes it. Unless the client asks us, can I see this property? And then of course we put it on. That's changed now. Legally, we have to show if the property meets within that client's parameter, we need to show it. We have to show it by law. We could certainly call and I guess try to get a CBC, Darren, a cooperating broker compensation, to up the commission before we even show it.
You sure can.
But that's neither here nor there. We still legally have to show it.
Mm-hmm. Yeah, it's tough. I mean, it's really interesting, isn't it? Because what we're going to do is we're going to plug in 2-bedroom, this much square footage, and certain parameters. Boom. Here comes the 10 properties. there is no longer a variable of a search field of the co-op. We will see the co-op when we pull it up, and then it gets into human nature, right? And so we will show all those properties. Whereas we wouldn't have seen, our list wouldn't have included a home that did not meet our co-op requirement. See the difference there? So now we will get the list, and then this goes back to how in the world are we going to police a realtor and which home they show first, right? That's an unknown. There's no way to, and we all know you can't see 20 properties in a day. You really can't even see. I mean, buyers get tired. And then if they're really, really looking for a home and they're not an investor and they're, their family's coming in 35 days and they got a new job in the outskirts of Anaheim there, they're going to pick one. And the first 5 they see, they'll probably choose one of those. So there's just so many factors. The thing about real estate, the hard part is we have to deal with human beings. If we could just get rid of all the humans, it would be a lot more easy. Like it would just be data. I was watching a show on how we got to the moon and back last night. And I'm like, that's really great that we got Apollo 11 and 12 and 13 was almost a failure. But I wanted to tap on the screen and say, you guys should try selling real estate. At least you're only dealing with like rockets failing. We deal with like people who change their mind at the last second, and whatnot. And the fact that you guys are really miracle workers. I mean, you think about the idea of taking a family that lives somewhere for many, many, many years, uprooting them and throwing another family in there in a mere 45 days and you guys do it every day. People have no idea, but human beings are amazing. I mean, if they're motivated, they get stuff done. So the reason that person moved out of that house is they wanted to sell. And the reason the other person would jump through all the hoops is they really wanted that house. So, but we definitely deal with a lot of variables, and this is going to create more variables for us, which we love. I mean, don't you think the COVID was bad, but it was almost getting too easy? Didn't we kind of need a little bit more of a, it's like up in your exercise, right? Sure, you can do 50 sit-ups, but let's do 55. You know what I mean? So.
I think Lance has his hand up, but we also have a question about short-term rentals.
Okay.
The question was asked, so does that make any laws against short-term rentals invalid? So.
Wow, that is a great question. I do not know the answer to that. Because you're right. Because if they put in that you can't limit your rights now, and there's already a short-term rental ability, and they wanted to go in and stop that, they may be prohibited from stopping short-term rentals. I don't think it's going to require short-term rentals, but I don't think the 25% talks to short-term rentals. I think it's only, let's call it, normal 30-day, et cetera, rentals. But it begs the question backwards is, well, what if they decided short-term rentals are a nightmare, and we allowed them, and we're about to have a meeting in March to get rid of them because there's just been too many parties and whatever. That's an interesting question. I don't know. I can look that up, and I'll have to get back to you on it.
Thank you, Darren. And Lance, do you have that?
Yeah. So you mentioned that we can't search by commission anymore, and we cannot. The CAR attorney mentioned that we can't, quote unquote, discriminate based on commission. But if an agent is showing property, I just want to confirm that they don't necessarily have to show them in any particular order. So if it happens that the one that offers the lower commission is shown last, that would not run afoul of the consent decree.
There's no answer to that. All right. I mean, how in the world are we going to, this is when if you think about the rules, we have rules, right? Let's talk about COVID. You can only have so many people over to your house and whatever. And I mean, once the door closes, it's really hard to police the public. And so here, let's take 10 houses. First co-op commission is you sell the house, you get a new car, a packet of gum, and 4%. And the last one is there's $1 co-op. What are the, are they going to be able to go back in and police and say, well, you're in bad faith. You showed the one that got a free car first. It's like, only because I mapped it. And if you look at, if you take, let's do it with me. If you take this highway, you go here, and there's construction now. So we got to move here. That's why I showed the one with the car first. I mean, it's insanity. There's no way in the world they can police it. You'd literally have to write down, send an email to your client who works for the DOJ and say, what I do is I only show the highest co-ops first or whatever. There's no way to police it. So they're right. Basically, they're starting with the concept that the co-op is known by the buyer. That's it. And from there, we're an uncharted territory.
All right. Now I emailed a question to Gina and you answered it. And the answer to the question, I just want to verify, is that even once we show a property, and even if we've signed a buyer broker agreement, we may still decline to represent the buyer based on the commission.
Always. So as somebody once said to me, and I stole it from them, we're not a bus. They can't just get on and ride the bus no matter what. We are allowed to step away from clients that are too difficult, that they want to buy that house, and the co-op is this much money. We can resign. And
we could negotiate the buyer at that point to pay the difference in commission.
That's why the buyer's brokerage is so important. You don't want to have that later. You want to have that in advance. You want to be able to chip down on that, right? So let's do the example. You sign a buyer's brokerage at 3. You find a co-op of 1. Your buyer is paying 2 points more than they expected on the home. That may break them. You could negotiate. You could say, look, I'll move my buyer's brokerage to 2, and then we'll take the 1, and that's a doable thing. And that way they're within their price point again, if they're tight on money. So it's just going to cause more discussions.
Yeah, I have found in the 14 years I've been doing this, and I started out working mostly with buyers. Now I work mostly with sellers, but I found out my experience with buyers is that they don't want to sign anything. Mm-hmm. They just want you to show them properties. Mm-hmm. So
it's not easy.
Yeah. And I think that's the things that we're going to, and we'll talk as soon as we finish here, we're going to talk about a couple strategies. But we're just going to have to get good at it. We're going to have to sell ourselves to the public that we're worth signing that buyer broker agreement. Right. And there's going to be a curve. There's going to be a curve. I imagine initially, most buyers are going to say, I'm not signing that. And then they're going to go to the next brokerage. And because of this, most brokerages are going to now instill the buyer brokerage agreement. And they're going to realize, it's not just a Lance thing. This is all agents are doing this. And it may take a couple months, but I think they'll realize this is the new norm.
Right. And there's always going to be a competitor that says, you don't have to sign that with me. Always.
I think another thing it may serve to do is push buyers directly to the listing agent.
Well, they're already doing that.
Hey, there was a question about whether or not the RTDD is overridden by a will. I don't know the answer to that. My gut reaction would be it's first in time, first in right, or second in time, first in right in this case. So the last signed thing would probably override, but I do not know if you have a will and you override that with your new RTDD. It would seem to modify your will because that's your last request. That's the whole point, is you're passing away and you made a last statement, so it should, but I don't know. That would have to be pursued with your estate planner.
Okay. And did you see the question there from George?
Thank you.
If you have a long-term tenant and the owner wants to sell, can they evict prior to listing or at time listing docs are signed? Some tenants make it difficult to show, especially with the pandemic.
Well, first of all, let's remove CDC completely, get that out of the way. And then you can move to evict. I think the better question is, did they want to clean the property out now, right? They would like it to be vacant while they're offering it for sale, correct? Is that her question?
I believe so, yes.
Because So the way it's described from CAR is it says that you can still evict for no cause if the owner is in contract to sell. So what does that mean? Contract to sell to a buyer. Do they already have to be in escrow? That could very well be. That's down to the nitty gritty detail. I don't know, but I could look that up to get to that answer. So eviction, vacant. But what I would say is what you do have the ability is to horse trade. And this is sometimes when we become the most powerful, when we reach out to the tenant and say, you know, let's get you out of this house and let's have you move on and see if that works. Now, if they're obstinate and they're like, I'm not leaving, you got to take it to the nth degree, you have to kick me out. I'll get the answer to that to you by the end of the week. Okay.
Awesome. And Vern, we're going to cover that when we do the brokerage agreement in just a minute. So, and are there any other questions for Darren? We're good? Darren, thank you. There was a lot to cover. I appreciate you very much. And, you know, we'll be in touch.
Yeah. Thanks for having me. Talk to you later.
Thank you.
Thank you.
Okay. Okay. So a lot of information. What we're going to do is I'm going to start right here under the buyer representation agreements. And, you know, how do I make this big? Let me just, well, you know what, let me just do it. I think, oh wait, slideshow. There we go. And concurrent. There we go. Okay, so buyer representation agreements, you know, many of us, we've used them in the past. We're going to talk about the 3 different kinds. This is straight from CAR. And I got to move this here. Let me get that. Oh, thanks. Okay, so advantages of using a buyer representation agreement. The buyer makes a commitment in writing to work for you. Buyer gives you the right to check their credit. Not that we ever have to do that, except maybe in leases. And in a procuring cause commission dispute, this is one factor in your favor. Back to this side. Okay. Confirms your commitment to working with the buyer, clearly identifies what broker will do. In the changing market, the buyer representation agreement is more important. Buyer payment is reduced if seller broker offers compensation. It gives you incentive to explore more properties not listed on the MLS, such as a for sale by owner, right? We all have, and over the last week, I can't tell you how many agents have come to me saying, hey, there's a neighbor down the street that wants to sell to somebody else and they just want to do the paperwork. It may be they're thinking about doing it themselves. There's a lot of that going on right now. So it gives you an opportunity. Other professionals providing services require contracts, and that is absolutely true. So there's 3 types of representation. The BRE is the exclusive for compensation. The BRNE is non-exclusive for compensation, and the BRNN is the non-exclusive, not for compensation. So in other words, exclusive, the BRE is irrevocable as well. So you've got an agreement that is in writing that it is what it is. Buyer agrees to pay you 3% commission. Whatever you get from the listing agent will offset that. And like Darren said, you can negotiate if you need to. But that's on any property that the buyer buys. The BRNE is non-exclusive. It only covers those properties that you show to the buyer. And then of course, the BRNN is not exclusive. It's not for compensation. It merely outlines the duties. You know, I'm gonna go right here because I think I'm away from that. It merely outlines the duties that the buyer has as a buyer and their investigation duties, and what your duties are as the agent. It has to have the beginning and end date, just like any listing agreement or any other type of agreement. It identifies the property. It identifies the compensation. It identifies any buyer credit for compensation. You can agree to refund excess commission to buyer, and I'm giving you, you'll see a sample pretty soon. Agency, it establishes agency, and buyer gives you permission to do a credit check if needed. The BRNE is the same as the BRE, except the compensation is only due if you introduce the buyer to the property or otherwise act on buyer's behalf for the property. It's more limited right to compensation, and the buyer may feel more comfortable signing this one. It's payment only if agent finds the property. And of course, the BRNN is the last one, agencies included. There's no specific ending date. It can be terminated at any time, and there's no right to compensation. So this one really does us no good. The only thing this does, again, is establish what your duties are and what their client's duties are. So other important considerations, it can be long-term or short-term. For example, you can tell a client, hey, let's try it out for a week, a month, and see if we're compatible. See if we work well together. A lot of people, their number one hesitation is, I don't want to sign this because I don't know you. And what if I want to work with another agent, right? That's what this is for. So when they start working with you, they're not leaving to go work with another agent. They're actually working with you, and they make that commitment to you. If you really don't know that person, it gets a little challenging. So that's why maybe saying, hey, how about we just do it for 2 weeks and see if you and I work well together. And at that 2-week period, if you don't think we're a good fit, our commitment's over with and you go somewhere else, or if we can extend it if we do work well together. They may be more open to that. So we just have to get really good at our buyer presentations. We're really good at listing presentations, putting our packet together, putting our bio together, putting our marketing together. We now need to do a buyer presentation packet. So when we meet a buyer or when the buyer contacts us, we need to have, like those links that I've sent you on the listing side, we need to be sending those to our buyer clients and saying, here's who we are. This is the company with whom I'm, with whom I have my license, and this is what we're going to do. This is why you want me on your side. You are selling yourself from that first meeting, and it gives them more of a sense of trust. And that's all the buyer wants. They want somebody that they can trust. That and a good deal, and we'll get to that. So it can be amended by using the modification of terms. And of course, you can focus on specific property type, geographic area, etc. And case law pulls such agreements as legally enforceable. So, don't assume your buyer's just not going to sign. You don't know if you don't ask. Of course, you're no worse off. So go for the close. And if they say no, then, we can go from there. But if they say yes, now you're safe, you're covered. And so the biggest objections are the length of the term, or sometimes just using the BRNE and selling your value. Okay. So the additional resources are the quick guide. I'm going to email this out to you with all of Darren's notes too, so you have it. But because we're really, really short on time here, we're over the 1 hour mark. I should be done here in about 5 or 10 more minutes. I just want to go through this with you. But read this because it matters how they work for you. Why should we use it? Why would a buyer agree to sign it? What type of buyer representation agreements are available, and what should be emphasized? And I think that's really important. The BRE, when you pull it up on zip forms, it includes agency disclosure, it includes fair housing, it includes, of course, the buyer representation exclusive itself. It includes the buyer inspection advisory and, of course, the consumer protection. And when you pull it up, this is what it looks like. Buyer representation agreement. Get out of there. Okay, so at the top, you put the buyer's name at the top, exclusive right to represent your buyer's name. Your buy grants, this is how you write it. Berkshire Hathaway Home Services, California Properties. I know we tend to want to shorten that up because it's long, and I agree it is long, but this is legally our name. Beginning and ending date, just like any contract, it has to have a beginning date and an end date. So we have it for, I put this one for 6 months. It could be for whatever you deem is appropriate. Property to be acquired, of course, I like it, any property in the Coachella Valley. Your client may very well say, no, I only want it for this one property, or I only want it for, Sun City, Palm Desert, or whatever. that's going to be between you and the buyer. But just remember, if they say, I only want, for example, Sun City Palm Desert, and now we move to Sun City Shadow Hills, you're going to need a new one of these for Sun City Shadow Hills. So we'll have to just work on verbiage of how to present it to your client. Darren, you had asked, when do we do this? At best, it's best to do it when you're first meeting your client. And basically, Darren's right. They sign agreements when they go to an attorney. If they're going to retain an attorney, they don't walk out of there without signing an agreement. If they are going to hire any professional, there's some kind of agreement between the two of them. So how we've been taught is, if you're employing me, I'll need you to sign a representation agreement and explain to them, this allows me to go look for property everywhere, MLS and off MLS properties. It shows that you have agreed to pay me 3% of the commission, unless the listing broker is offering that commission, and then I will take what the listing broker gives, and we'll get down to that portion. But present it at the beginning before you get to work, and then you don't have to worry about it. It's kind of like, and like the purchase agreement, you're not going to leave out certain things of the purchase agreement to negotiate later. You want to get everything negotiated up front so there's no argument in escrow. Same situation here. You want to get this done up front so there's no arguments later. So if you look, 1A needs to be filled out. 3A, you come down here, and this is where you see the compensation, the amount of compensation, and you check the box, and 3% of the acquisition price. And then if you go to the next page, right here, compensation payments and credits, buyer is responsible for payment of compensation provided for in this agreement. However, if anyone other than buyer compensates broker of services covered by this agreement, that amount shall be credited toward the buyer's obligation to pay for commission. So it basically says right there what's going on. C2, this is your protection period. You've been out showing the buyer property, and let's say the buyer says, "No, I'm not feeling it right now." Your agreement expires with this buyer, and a month later the buyer goes to the listing agent and says, "You know what? I want to buy this property." This protects you for that period of time. Okay, and so as you can see, it just goes through, talks just like any other buyer agreement, scope of broker duty, what the buyer obligations are, and then everybody signs it, okay? So that is the buyer broker agreement. The BRNE looks almost identical to it, except the properties are different up at the front. And of course, the BRNN looks exactly like it, except it doesn't have the compensation outlined in it. Are there any questions so far? Okay.
Yeah, Gina, does the commission that's in the listing, if it says 3%, then can we hold them to that? Do we have to have the BRNR?
Good question, but you'll have this signed when you first start working with the buyer. So right now you don't know what properties you're going to find, right? This is just, hello, Ellen, it's nice to meet you. Here's some information about me and my company. If you're going to employ me to find a home for you, I'll need you to sign a representation agreement, and you're going to go for and explain it. Ellen, you're going to say, okay, great. You're going to sign the paperwork. Now I'm going to go to work. I'm going to get on the MLS, and I'm going to start looking for properties.
Right.
So yes, but if it's the 3%, then of course I just take the 3% from the listing side, and the buyer pays me nothing.
But now if it says 2.5% and you've put 3% on the form, can you still use that form, or does it have to actually state?
No, you can still use that form. Nothing changes. The only thing that you have to, you have to ask yourself, do you want to raise or not? And that's up to you. This is your business, and you can handle it however you want. But if the MLS is offering 2.5% and your buyer signed a form that says 3%, you can certainly agree to take that 2.5% and not charge the buyer that
Okay.
extra half. or you can credit that buyer back that extra half, however you want to do it.
Okay.
It's negotiable, but again, it's coming out of your pocket, so that's
Right,
how you want
right.
to do it.
Okay, thank you.
When it comes to lending, how is this gonna show up on lending when all of the buyer fees have to disclose to the buyer?
So did you guys hear her question? Okay, when she's asking about the lender, how this affects the lender, when you have to disclose everything to the lender, how does this affect the buyer's side? And the answer is, when we find the listing, as we see it, if you're going to, if it's a 3% listing, it's irrelevant, because the buyer's not paying us anything, the money's all coming from the listing side, right? But if it's let's say it's a 2% listing, then we're making the decision, are we gonna charge that buyer that extra percentage? If you say, yeah, I want 3%, I don't want 2%, and the buyer knows, then we disclose to the lender, the buyer is paying us 1% of this purchase price, and the listing side is paying us the rest, and they have to work all that in. Does that make sense? Okay. Okay. All right, did you guys hear that? And do you have any more questions on this? Because there's a lot to take in here, you guys. This is a big paradigm shift. It's something that we should have been doing, I guess, all along. It's all about antitrust violations, and this is why the Department of Justice is involved. And so this is really one way of, the NAR, if they can be said to be watching our backs, this is one scenario where they are putting these things in place.
So once on the MLS that, we're getting paid a certain amount of commission, once we're into contract, it cannot be changed. The seller cannot say, you know what, I'm not gonna pay any commission.
Oh, no, it can't be changed.
Okay.
Yeah, no, that's what's posted on the MLS is what it's done. And there's hearings about that all the time. Yeah. Yes.
Yeah, that's what I was worried, because now, because it's gonna be so flexible, I mean, in the buyers or seller side, because if they know about this, I think they're gonna negotiate more with us.
Well, and there's going to be a lot of changes. I mean, there's something to be said to that. That now the sellers might be coming back saying, well, I'm only going to pay a 3% commission because I know the buyer's going to pay 3%, right? We're going to have to jump off that bridge when we get to it. We're going to have to explain and get really good at explaining why we want to offer that full commission, because many of the buyers are not going to be able to pay those fees and buy your home. So,
Yeah,
Because many of the buyers are already asking for closing costs.
that's correct.
Because they don't have the money.
Exactly.
And they're not gonna be able to purchase this home, because on top of that, they're gonna have to pay a commission.
That's correct. And so we're just gonna have to explain that to the sellers. And when we're fighting for our commission, I mean, we've gotten so lax of reducing our commission. And I mean, it's like people come to us all the time and say, well, will you do it for 5? Will you do it for 4? Will you do it for 3? Really, I only want you to do the paperwork. But it's not, I mean, it's your liability, it's everything. We're not just typists that go into the computer and type out forms and it's done. We are actually negotiating and working and moving to get these transactions closed. And it's a lot of work. It's a lot of work. So we need to be able to sell our services to the sellers. We need to be able to sell our services to the buyers. And the agents who get best at that are going to make money, and they're going to continue making money in the business. But good questions and things to really start thinking about. And I'm sure you're going to have a lot more questions, and just, send them off my way, and I'll funnel them through Darren if I can't answer them. But, it's just a change, and it's okay, because we're up for it. Okay.
Let's just not tell the sellers.
Gina, I have a question.
They'll know. Yes,
I have
Lynn.
a question. Was there anything else in this consent decree besides the buyer commission disclosure? Is that the only thing that it included?
Well, it's antitrust, is what it's avoiding. Antitrust violations, saying that we're all plotting to only show certain commissions. We're not showing all available listings to a buyer, even for sale by owners. I mean, and that's ridiculous, because they don't want to pay a commission, and we don't want to work for free. So we're back to the buyer broker agreement. We're okay. If we have to show these properties, then we are going to get paid. So Either we're gonna get paid by the seller or we're gonna get paid by the buyer, but we need to get paid if we're gonna work.
But there were no other issues besides commission and buyer commission and disclosing it that is a part of this consent decree. That's the only issue?
I
There were
haven't
no,
said anything else,
okay.
so
But it
All
can
right.
make or break a purchase for a buyer.
absolutely. Yeah, it's a big deal. It's a big deal. But we'll just keep focusing and we'll just start pulling out these buyer broker agreements and, you know, putting them in front of the buyers and getting them signed or bottom line is if you don't get good at signing the buyer broker agreements, you still have to show all the properties that are available for this buyer. So you're either going to make no money or you're going to get really good at signing these agreements and making a lot of money. So we are where we are here. Okay, quickly, and then we can talk as long as we want to afterwards. Last week, we looked at the listing presentation boxes. Don't forget, you can go to marketing, bhhsproperties.com and ask them to send it to you. You have about 5 on your shelf ready to go, and now you might want to put together those with the buyer guides and create some nice buyer presentations for your buyer as well. But now what do? We have tools, we have systems. I hope you understand, and I'm going to cover this quickly, what you have in your hand to get more listings, and that's the Apex Concierge program. And I know I've mentioned it to some of you, and I've heard what's Apex. And Apex is a very, very cool tool that many agents are starting to use. Home services that move you. In fact, what Apex does, and there are flyers, there are marketing pieces that are already available on the VAC. This particular flyer you can print out, it's a Word document from the VAC, and I'll show you where to get it, but you can put your photo on it. But I mean, anywhere, renovation projects, cosmetic updates, and then there's elite services as well that come with this. You could be farming with this material, and maybe if a seller is sitting there thinking, God, I'd love to sell my house, but I've got some work, I got to paint, I got to do this before I even think of doing it, and they're putting it on the back burner. Now they get this flyer or postcard from you saying, hey, I've got these things lined up that can take care of it all, and there's no money out of pocket for you until you close escrow. That could be a game changer, and that could bring somebody from, well, I'll do it later and list it later to, hey, I might as well do it right now. So it's a great way to get your foot in the door. On the flip side, we've got the Apex Forward, the buy before you sell. We have frequently asked questions. Again, this is a tool that's designed to get you business. So don't just wait till the business comes and then you've got to pull a flyer and say, oh, what is this about? Let me see if I can learn about it. No, learn about it now and get out and market with it, and you'll end up with more listings and buyers because of it. So that's what I want you to really take away from this. To go onto the VAC and you'll click on the document center, and then from the document center right here, you'll see Apex, you'll click on marketing and then Apex marketing materials. And then under the Apex marketing materials, look at, there's 8 flyers here that's already done. And I didn't include them all because I ran out of room on this page, but these are all the social media images that promote it. And you can use these on Facebook and Instagram. So literally on the VAC right now, we have 2 months, once a week for 8 weeks, marketing that you can be getting out in your drip system, that you can be putting out on social media, that you could be mailing to your farm. So, I mean, it's an awesome tool. I recommend you just jump on. So everybody starts talking about, wow, Berkshire Hathaway, they've got this stuff going on. And that's the buzz we want to create. So, oops, go back to this. So from VAC, if you wanted to send out some postcards, there's some beautiful postcards about Apex. You're going to click on Deluxe Brand Marketing from the VAC. You'll click on Print, and then you'll click on Series. And once you hit there, you'll see Apex postcards. And there's a bunch of them. You can just go in and select and create an order and order some postcards for your farm that way. Use the tools that we have. They're designed to get you listings and more buyers. And so let's really be proactive about this. Let's jump out. If you're not sure what it is and you're scratching your head right now saying, what the heck is Apex? And I have no idea what she's talking about. Call me. Call me. Let's get together. Let's really talk about it. Check out some of these marketing pieces because they're a hot commodity and you will get more business if you use them. And then, of course, any questions, marketing, our whole department is there waiting to help you get your name out there. Congratulations, Indian Wells, top 20 agents in 2020. And this is just for our office. We are awaiting final numbers from the company for the big award ceremony that's going to be in March. And so we're really excited about that. But congratulations, #1 for 2020. Here's the top 20 Mark's Real Estate Group's #1, woo, woo, woo. George Lopez and Associates. Then the Kennedy team, woo, woo, yeah. Gary Morlock, Debbie Billman, #5, Ann Stark, #6. Josie, 7, woo, woo. Mark Wasserman, 8, Maria Molina is 9, Teresa Kagan is 10, Donna Ambrose 11, 12 is Andy Torres, 13, Alonzo, woo, woo. Katie McLaren is 14, Heidi is 15, Kathy is 16, Lisa Stahl, good job, 17, Linda Kroll, 18, Deborah Farrell, woo, woo, 19, and Tom Hathaway, Hurd is 20. So congratulations to all of you. I'm very proud. I got to tell you, it's so close because you guys did a great job. And despite all the challenges and the chaos of 2020, many of us just really, you guys hung in there and you just did what you had to do and decked in our beehive and bodyguard and swords and getting out there going, okay, I'm here. You did it. So congratulations to you. Can't wait for the awards. And when you get the invitation, save the date. Make sure you save the date. March starts. It's going to be virtual, but it's going to be incredible. And literally, even with convention that's coming up in March for Berkshire, it's almost like you're there. It's really like walking through a convention center. It's going to be incredible. Okay, Mark Stark today, his live Facebook Live is all about top ideas of getting listings. And so you don't want to miss it. It's today, 1 o'clock is 1 or 1:30? What? Oh, 1 o'clock, 1:30. 1:30. I know. I'm confusing this with Market Watch that's also today. But here's the thing. If you miss Mark's thing, just go to his Facebook page and you can watch all his past videos. You guys, he's brilliant. He has so many phenomenal ideas. And if you, I would venture to guess, if you would just jump in, listen to what Mark had to say and implement one thing a week, your business would be soaring, just absolutely soaring. It's that good. So I encourage you to do that. Today at 1 o'clock, we've got Market Watching at Palm Springs Live, does these twice a year. I'm going to be playing it here in the office. So if you'd like to watch it, if you didn't buy your own ticket, you're welcome to come in and watch it here. But I think it's really important we see what's going on in our valley and how, how everything is affecting us. Okay, any plugs or wants? Whew, sorry, I went over. Let me quit sharing here and just open this. I think we're good here. I don't know what all that is, but okay, so I don't know how to put your hand down, Lance. Do you still have another question? Wait, lower hand. There we go. Okay. I've not had to do that before. Okay, any other questions?
No more questions, sorry.
No, that's okay, that's okay. Questions, or wants? Deborah?
Transfer of the taxes, does that only have, like, say for instance, you have a house and somewhere in California, you buy another house in California, does that only apply for California? Like, you can't go from California to Idaho, can you, and have that? Yeah.
No, it's gotta be within the same
It's
state.
gotta be in the same state. Okay, that's what we're thinking. I was just making sure.
That's okay. Her question was on transfer of taxes, if it could go out of state or if it had to stay in
I
California.
was hoping.
Yeah, I think it has to be in California, but I'd have to confirm that for you. Okay. All right, anything else? Hi, Debbie. Debbie's fine. It's nice now I can see everybody's face before I just saw the screen, so. Okay,
Gina,
yes, Eileen.
quick question. I'm getting a bunch of emails from CAR and Glide, and I guess they are in a dispute. I mean, is the bottom line, we can still use Glide, it just won't be integrated with CAR and zip forms anymore?
Well, it is linked still to zip forms because I've been using it.
It's supposed to link sometime this week. It's supposed to link.
It's not, it's between Lone Wolf and Glide, not CAR and Glide. It's some kind of intellectual property dispute.
Right,
But,
right. I'm sorry. Yeah, Lone Wolf.
yeah, but there is going to be, I did see something from SkySlope that SkySlope will begin integrating zip forms into their program. So I don't think there'll be a need for Glide anymore once you can do that, but that remains to be seen.
Yeah. Lots of stuff going on. Keep it, keep on top of it because there's, and Lance is right. SkySlope is going to be integrating lots of updates, lots of changes. So stay close, read your emails, and we'll get better all the time and keep building our businesses. So, but right now we can still use Glide, I think. Okay.
Yeah, Gina, there was a new email just yesterday about that topic. You might want to take a look.
Okay. You said it came from where?
It came from, let's see, the Glide team.
Oh, okay. Okay.
Right.
Probably in my promotional tab. I'll go look.
Yeah.
Thank you.
Thank you.
Okay. Anything else?
So when are we gonna start using this VRE form?
Today.
Okay.
When do we start using it? Today? Yeah. And so if you have questions on it, let me know. But go into zip form, pull one up and just read it. That's always your best start point is read the form so you understand what you're presenting to your client. If you have questions or concerns of how to present it, I'd be happy to role play with you just to help you get over that, how am I going to do this? We could throw out some scenarios so you feel really comfortable when you get in front of your client. Okay, so if there's nothing else, thank you for hanging with me. I know we went 30 minutes over today, but it was such an important topic that we really needed to get you updated and armed for bear. So if there's no more questions, I just want to say thank you for everything that you do, and let's make it an awesome week.
Thank you.
Thanks, Gina.
Thank
Bye-bye,
you.
Gina. Thanks, Gina.
Thank you.
Awesome.